Hey, can you hear me okay?
Yes.
Yep.
Thanks.
Yeah.
Perfect. Are you kind of running things for us, Danette?
One moment, I'm having some difficulty with my sound.
But and we'll see in the system. Ask if every,
Can you guys hear me now?
can anybody hear us?
Can you hear us?
Go, select speaker, sing in the system. And can you guys hear us? Yeah.
Okay, good,
Okay.
thank you.
Yes, I can hear.
All right, turn the volume. Oh. Okay. We're still missing the attorney. Give us a few minutes. Mute up. Can somebody say something so we can check our audio?
Hi, Aubrey.
No, we're still not hearing. Hold on. Okay, can somebody say something again so we can hear?
Hi, Danette.
No.
Can you hear us?
You're on mute.
Okay, guys, we're all good to go. We are recording. So go ahead and proceed.
Alrighty, welcome everybody. I'm Aaron McKnight. I'm the appeals hearing officer, and we're here tonight to hear the appeal of the denial of a certificate or a certificate of appropriateness for a fence at 610 East South Temple. I guess all of those will be participating. If you'll just go ahead and state your name and let me know who you are and who you're representing.
My name's Justin Bear. I'm the attorney representing the McCarthys, the owners of the property.
Thank you, Justin.
I'm Sarah Jabronic. I'm a senior planner in the planning division.
Daniel Echeverria, Planning Division as well.
Courtney Lords, the attorney for the city.
Okay, thank you. So this is a hearing where I will be hearing, I'll be making the decision de novo. I have received a staff report, which includes the original denial, as well as the appeal with argument from Mr. Bear, and then the city's response. What we'll do is go forward then with Mr. Bear. You are the appellant and have the burden of proving that the denial was incorrect. And so I'll have you start. We'll then have the city respond. I believe this is a public meeting. Is that right? Or there needs to be a public hearing for this?
No.
No? Okay. I was wrong on that. We will not hold the public hearing then. After the city's had a chance to argue, we'll have Mr. Bear then provide any rebuttal. I am gonna try and hold the parties to the half-hour limit each. So Mr. Bear, you've got a half hour between your initial presentation and your rebuttal. You can divide that however you want, but I do want to try and keep within those time periods if we can. And with that, I'll go ahead and turn it over to you to present your case.
You can still hear me okay?
Yep.
So I just wanted to give a little bit of a background. The property at issue is known as the Walker McCarthy Mansion. It's on the historic register, built in 1905 for Matthew Walker. The property was acquired in 1999 by the Phil McCarthy interests, and the McCarthy family has invested substantial funds to restore this Walker house. And it's not too much to say that, but for the McCarthy family and Phil McCarthy in particular, this historic property in Salt Lake City likely would have been lost. And I mention this because the McCarthys have worked to preserve this property, and the reason for this fence is consistent with that whole effort to preserve and to protect this property. The fence, it provides protection, it's consistent with the other historical properties in the immediate area, and it preserves that view shed corridor that's so desirable on South Temple. We mentioned in our appeal letter that for several years there was a problem with trespassing and vandalism that's caused damage to the property. And it's not just that there's trespassing, but there is substantial damage that has occurred and the threat of significant harm. So we mentioned several of these things in the appeal letter, but for example, there have been hot plates found that have been plugged in and turned on that obviously cause great risk of fire. There's a hose bib that has been left on and used and left running, which could cause significant problems with erosion in the foundation of the property. The parking lot has regularly been used as an outhouse. And I don't know if this was mentioned in the appeal letter, but there have been people found sleeping under the heating exhaust systems, which causes threat of their personal safety. So these are just a few examples. There are others that are listed in the application in the appeal letter. These acts of vandalism have required the owner to make additional repairs and to invest in additional sums into the property, but they're also causing a threat of greater harm. So in its effort to preserve and protect this property, the McCarthy family filed an application with the city in 2021 to build a fence. This was briefly addressed in the materials. To be honest, I'm not sure what happened. It sounds like there's a difference of opinion. The McCarthys assert they never heard back from the city, and we mentioned this simply to say they didn't just build the fence, they did file an application, and through what appears to be a misunderstanding, they moved forward with building the fence. The fence was built, it was a 6-foot fence on all sides of the property. We attached photos to the application and the appeal letter that show this fence is consistent with the character of other fences in the neighborhood. The side and the rear fences have been approved, so a certificate of appropriateness have been issued for the side and rear fences. The only issue we're dealing with is the height of the front fence. And so consistent with that, I think it's also important to say we're not talking about the materials or the look of the fence, it's just the height. So we'll essentially rely on the application and the letter for the main reasons why we're doing this. I'd primarily in this hearing like to address the staff report that was given to us last Friday. It's dated September 18th. And there are 3 main points that the staff report addresses that we want to respond to. The first pertains to this idea of the finished grade. Section 21A.40.120E6 of the Salt Lake City ordinances states, the height of a fence, wall, or hedge shall be measured from the finished grade of the site as defined in section 21A.62-40 of this title. And that section defines finished grade, and it's grade comma finished is the way it's listed in that ordinance, as the final grade of a site after reconfiguring grades according to an approved site plan related to the most recent building permit activity on a site. So these ordinances refer to the finished grade of the site and not necessarily the location of the fence. So as I read these ordinances, I think they're interpreted to mean the measurement of the fence, the height of the fence is dependent on the finished grade and not necessarily the exact location of where the fence is located. So we submitted several exhibits with our appeal letter. Exhibit F that we submitted on page 25, it has plans that show the fence is measured from the finished grade is not consistently 6 feet because there is a slope from the sidewalk to the finished grade of the property. The height of the fence from the finished grade varies between 4 and 5 feet at the northwest portion of the property, and it is closer to 6 feet on the northeast portion of the property. Now, I don't know if you'd like me to share my screen and show some of those, or if you have those and are looking at them.
So I'm looking at page 23 of the staff report. It's labeled Exhibit F. But if you'd like to share, just to be sure that it's clear what you're referring to,
Okay,
that's
yeah.
happy to
So let me
have you do that.
share this screen. So can you see this PDF document?
Yeah.
So this is Exhibit F that we submitted with the application. These are plans for a proposed fence and gates. And as you look in this bottom right-hand corner, it's Exhibit F, page 25. It shows the finished grade on the typical fence section at the northwest, that it varies between 4 and 5 feet. So that's from the grade to the height of the fence. On the northeast section, it is, because there's not as much slope over there, it is that 6 feet. There are also some photos. As we look at, this is Exhibit F, page 24, you can see on that northeast side of the property that there is a slope, and the fence sits lower than the top of the finished grade. So that is relevant as we consider the height of the fence. Staff report asserts that the ordinance simply is essentially the height of the fence is the height of the fence, but I believe that this ordinance does mean that fence should be measured from the finished grade to the top of the fence so that it is not consistently 6 feet throughout the property. The second point.
Can I ask a question about
Go
that?
ahead, yeah.
So, on many properties, grade varies wildly throughout the property, right? I'm thinking specifically in my neighborhood, it's kind of on a sloping ridge. And, you know, some places on the property, are really low, and then it goes way up high. What grade specifically should we be looking at? Where
Well,
there's varied grade?
Yeah, where it's varied grade, the ordinance doesn't deal with that. I think first of all, we do need to recognize the fence does need to be a consistent height. I mean, to have a fence that varies with the grade of the property would really be aesthetically, it wouldn't make a lot of sense. As we consider this property, this specific property, where there is quite a bit of height difference, the concern, and I think the reason it is measured from finished grade, is a 4-foot fence would be quite easy to get over and onto the height on that one side of the fence. So primarily because we're looking at protection of the property, and we are asserting that the height of this fence is significant because it's designed to protect the property, we assert that it should be measured from that highest grade point, because that would make it, a 4-foot fence would make it much easier for someone to get over, and it wouldn't be a substantial barrier.
You're saying it should be measured from the highest grade point on the property.
Right, I believe that's how it should be considered.
Okay.
Any additional questions there?
No, thank you.
Okay. The second point that is mentioned in the staff report is this idea to protect the property. And that really is primarily the reason that the fence is 6 feet and why we assert it needs to be 6 feet. In response to that, the staff report has some correspondence from Commander Clough from the Salt Lake City Police Department. And I just want to read this email, and the email is attached to Exhibit C of the staff report. Now, the email isn't from Commander Clough, it's from a member of the staff, and they just included his recommendations. But I think his recommendations they're significant. So he said, for the areas with the 4-foot fencing, he recommends some sort of hostile vegetation as a deterrent, along with good signage on the front fence line, such as a sign indicating that it's private property, they're on camera and will prosecute. Those things are helpful, especially if it has to go to court. He said that with that, it's hard to argue that you or someone didn't know you shouldn't be there on that instance. Hostile vegetation could include rose bushes, holly, barberry shrubs, firethorn bushes, and bougainvillea, I'm not sure how to say that, or others that aren't very inviting to people and will help deter jumping the fence or encroaching on the private property. These would require a maintenance plan to ensure the vegetation doesn't overgrow the fencing onto the sidewalk. So I think that correspondence from Commander Clough is significant because it seems to me it inherently recognizes that a 4-foot fence is not enough to deter trespassers, because he's recommending other things that should be in addition to the 4-foot fence. Now, we mentioned in our appeal letter that based on the denial, the city's denial, we took that reasoning and we tried to summarize the city's decision to not allow a 6-foot fence in the front. And I don't want to put words in the city's mouth, but as I read their denial, I identified basically 5 main points that the city was pointing to. Number 1, the height disrupts the visual continuity of the house and the street. Number 2, it does not provide transparency. Number 3, it impacts the community. Number 4, it alters the appearance of the streetscape. And number 5, it alters the character of the neighborhood. And I mention those because as we talk about these suggestions by Commander Clough, what he's saying is, with a 4-foot fence, let's do these other things in addition. Let's put bushes, and I'm just going to call them no trespassing signs. But if we consider the reasons why the city didn't want a 6-foot fence, these visual things, the character of the neighborhood, I assert that a 4-foot fence with bushes and no trespassing signs is much more different and distinguishable than is the fence as it currently sits. As I went out and drove down South Temple today, I didn't see any other properties with bushes or no trespassing signs. So if the concern is the look and the feel of the fence, it certainly seems to me that Commander Clough was saying that a 4-foot fence by itself is not enough. So if we balance the need to protect the property with the visual aspect of it, certainly the 6-foot fence that is there seems to be much more in line with the character of the neighborhood. I did take, now I know we're not presenting new evidence. I did take a photo when I was out there today. Would it be okay for me to show you that photo that I took today?
Yeah, that's fine. You can present that.
So this is and I just took this as I drove past today. So you can see the fence in front of the property. It doesn't impair the view of the property. It was recently, within the past year, a fountain was constructed. And so as you look at the views and think about how different that would look with a smaller fence, but then with bushes and with signs saying no trespass. So certainly we believe the visual impact of this current fence as it exists is much less significant than a 4-foot fence with bushes and signs.
Yeah, that makes sense. For the record, I think it looks very nice.
Yeah, and so consistent with this, the third point is the consistency with the neighborhood, the look, the view. We argued in the appeal letter that the height is consistent with the neighborhood. We included photos and several examples of other properties. The staff report goes through each of these properties and explains why those higher fences were allowed. Now, we're not asserting that the city waives its right to assert the ordinances because of other approvals, and we do recognize that that each situation is unique. But I think the point is, as we're talking about the character of the neighborhood, the overall look and feel of this historic district, this 6-foot tall fence is consistent with the neighborhood. We did attach photos, but again, as I was out there today, I took a couple other photos. Would it be all right to show those as well?
I'm okay with it. I guess I should have asked on the last one if the city has an objection to that.
Do not have an objection.
Okay, then yeah, go ahead then. That's fine.
Now, these are, I mean, they're essentially similar to the photos that were attached to our application. They're just maybe a little bit bigger and easier to see. This is right across the street from the subject property. That's the governor's mansion. And this fence, as you go out and look at it, it's essentially identical to the fence that's been constructed in front of the Walker McCarthy property. And it's built through the entire block. So it goes to the next one. And so this next photo is just the end of that block in front of this other home. So those two properties are right across the street. The fence, the iron, the decorations, they're identical. And that fence is taller than the one that is on this property. So we're asserting that the overall visual impact from the fence, it doesn't detract from the historic character or importance of the property. It doesn't hide the home. It's consistent with the look and feel of the neighborhood. And so essentially what we're talking about here is the city would allow a 4-foot fence. So it's what we're talking about is the difference between the current 6-foot height and a 4-foot height. And because of the need to protect and preserve this property, we assert that there's certainly this 6-foot fence is needed. And it is a much better option than a 4-foot fence with other bushes and signs that say keep out. So for those reasons, we would ask that the city's decision be overturned and a certificate of appropriateness be issued for this fence.
Okay. One question I have for you, and I have kind of similar question for the city when it's their turn. I know there's we have section 21A 4120, which is outside of the purview of the historic district and the certificate of appropriateness. It's a statute that applies to properties generally, but it prohibits a fence taller than 4 feet. Is there anything in the historic district code or anything that would kind of overrule an ordinance of general applicability? I know you cited in your materials, sorry, let me pull it up here. Section 21A 34020A, which talks about the purpose of the historic overlay district. Is that basically the meat of your argument there, that would overrule then the ordinance of general applicability, or is there something in addition, do you think?
Yeah, that statute, section 21A.34.020, that has I've got a few of those sections cited in the letter, but let me just jump to that, because that section contains the city's reasoning for not allowing this. So essentially, this historic district, in my understanding of it, it operates as a variance. And so there's some flexibility within the historic district because of the unique nature of these properties. So if the historic, if these sections in that historic ordinance are satisfied, then it essentially operates as a variance that allows additional things to be done that would be like granting a variance. So
Okay.
That's where the city's denial came from. That's what we addressed in the staff letter. And so we assert that we have in fact satisfied the requirements of that ordinance. And like we mentioned, one of the primary purposes of the historic district is to protect the property. So as we consider the need to protect this property, we would assert that that does override the 4-foot height requirement, and particularly as we talked about the finished grade, that it does allow fences to be considered from the finished grade rather from the base of the fence.
Yeah, because to a certain extent, that's kind of a hang up that I'm having, just to show my cards a little bit, is we've got this ordinance of general applicability that just outright prohibits it. Nothing explicitly refers to the fences in the historic overlay. I think the residential, I forget their name. The residential guidelines discusses it briefly, and that's cited in the city's decision, but I guess I'm just trying to understand whether or not a certificate of appropriateness can be issued contrary to this other ordinance.
Yeah, I'm looking at the stat. So the section is 21A.34.020. That pertains to the historic preservation overlay district. We cited section A that talked about protecting the property. And so as in subparagraph E, it says that a certificate of appropriateness is required. And it talks about a certificate of appropriateness for any exterior alteration of the property or structure, new construction. And so I believe it does address, it might not specifically address fences, but it does make provisions for a certificate of appropriateness for construction, because the whole purpose for this historic district is to protect and to preserve these historical sites.
Mm-hmm. Okay. Um, would you like to reserve the rest of your time then for rebuttal?
Yes, thanks.
Perfect. All right. Ms. Lords, we'll now hear from you, from the city. Or I guess is it Ms. Sorry, I'm gonna say your name wrong, I'm sure.
Javoronic.
Javornorok? I sorry, can you say that again?
Javoronic.
Javoronic. I know you said it before and I forgot. I'm sorry.
No problem.
Ms. Javoronic or Ms. Lords, however you'd like to handle this, we'll turn the time over to you now.
Ms. Javoronic will take the lead on this.
Great.
Thank you. So as we've been discussing, the issue is the installation of the 6-foot fence in the front yard. And there is the requirement in 21A 4120 regarding the fence height that limits those to 4 feet in front yards. And so staff have found that it does not meet that front yard fence height requirement, and it also does not meet three of the different standards in 21A 34020G. Staff found that it didn't meet standards 2, 3, and 8, and that it would alter the character of the property. It does not have a historical basis and alters the streetscape, and it's not compatible with the neighborhood. I will also say that there are provisions in 21A 06050 regarding the Historic Landmark Commission and their jurisdiction. And there are also some delegations there to the planning
Sorry,
director.
can you cite that code again for me?
Sure, it's 21A 06050.
Okay.
And so that addresses the Historic Landmark Commission and their jurisdiction and authority, and what they have the ability to make recommendations on. And so in that section, it does give the Historic Landmark Commission, and then also delegates to the zoning administrator, the planning director, and staff areas where they can make modifications from those standards, like we were discussing in 21A 40 regarding fence height. And so one of the things that is listed there is fence and retaining wall height. And so if the commission or staff finds that a fence meets the standards in 21A 34, they can make a recommendation for allowing additional fence height. But in this case, the staff found that it did not meet the standards that are in 21A 34020.
Okay.
That's all that I have at this point.
Okay. And I'm gonna ask you to give me that last code that you cited again. 21A 34 what?
020G.
020G. Okay, yeah,
Mhm.
the standards for certificate of appropriateness. Okay.
Yep.
Perfect. Okay. Thank you. Anything to add, Ms. Lords?
Not at this time. I might during the rebuttal period.
Okay. Well, so I kind of intend well, I think this is the chance for the city to offer their rebuttal where Mr. Bear's already gone. But let me just ask the city generally again, and I'm gonna ask the same question I asked Mr. Bear, which is the way I read the code, you've got this ordinance of general applicability that says no fences over 4 feet. Does a certificate of appropriateness allow to anywhere for an ordinance of general applicability to be overruled? Or when granting a certificate of appropriateness, do you look at the other standards in the city as well?
The most important piece when we have an overlay district, such as the historic district, we will refer to those guidelines to be more appropriate with the district in which the property is located. I think it's important to note here that Mr. Bear pointed out that there's safety issues and it's very important that we address the safety issues. I want to make sure that it's clear that the historic variance language in the code speaks to the purpose of the historic district. And it is to allow for variances to keep a property consistent with that historic district, not to provide additional modifications or to make exceptions for safety issues as he's raised.
Okay. So I guess, he cited this 21A.34.020A where one of the purposes is, and sorry, I don't want to read through them all. I'm just going to pull up the ones that he cites here. Right, so subsection 1, provide the means to protect and preserve areas of the city and individual structures and sites. I guess you said that the historic preservation overlay isn't to create additional security. How does that jive with that subsection that he cites there?
We would point you down to subsection G of that same section of the code.
Mhm.
Standards for alteration of a landmark site or contributing structure. It says the historic character of a property shall be retained and preserved in sub 2. Sub 3 is all site structures and objects shall be recognized as products of their own time. For alterations or additions that have acquired historic significance in their own right shall be retained and preserved. Talks about distinctive features, architectural features, goes on. And there's nothing in there really dealing with the safety feature. It's just to preserve the character of the historic overlay.
So you're saying that the purposes aren't to protect or create security necessarily for the property, but more for the historicity of the property. Is that right?
Correct. Correct. And I would also note that other than what was provided in the letter, we have not been provided any evidence of damage to the property other than statements that were made in the letter.
Okay, yeah. But and I don't think in the letter it talks about any damage that's been done, but it certainly talks about damage, potentially very dangerous situations to the property, right? I mean, I think water being left on or hot plates being used right next to the property and left on would be significant dangers.
I would also just say that the potential of that is not evidence of that.
Fair enough. Okay. Anything else from the city?
I have nothing else to add. Sarah, do you?
No, I do not.
All righty, thank you. Mr. Bear, now's your chance to offer some rebuttal. What would you like to present in that regard?
Yeah, so I've taken a look at this statute in regards to your question. So the ordinance 21A.06.050, and it's subsection C6. So this section pertains to the Historic Landmark Commission. And when it talks about a certificate of appropriateness, it refers major issues to the Historic Landmark Commission and minor issues, which, I mean, we don't need to go into it, but this fence is one of those minor issues that they give jurisdiction to the zoning administrator to take care of.
Yeah.
So subsection C talks about the jurisdiction and authority of the Historic Landmark Commission. Subsection 6, so C6 says their jurisdiction is to review and approve or deny certain modifications to dimensional standards for properties located within a historic preservation overlay district. The authority is also granted to the planning director or designee for applications within the historic preservation overlay district that are eligible. And then it lists the certain modifications to zoning district specific development standards are listed as follows and are in addition to any modification authorized elsewhere in this title. And then it lists A, overall building and accessory structure, B, building and accessory structure wall height, C, accessory structure square footage, and D, fence and retaining wall height. So that section does give the Historic Landmark Commission jurisdiction and by designation of authority, the city to make changes to the standard zoning ordinance when the properties are within the historic overlay district. And it specifically mentions fence and retaining wall height.
Okay.
In regard to the preservation of the property, and I recognize that there is a desire to preserve the historic nature, but the statute that we quoted specifically says it's designed to protect and enhance the attraction of the city's historic landmarks and districts for tourists and visitors. And I don't know how we could interpret that as anything other than protect. And vandalism and threats to the property and security certainly are a danger, and it's needed to protect the property. I would also point out that there was recently a fountain constructed on the site. And so there's also a need to protect that additional feature and to make sure people aren't stumbling onto that so that it's right out in the open. So in regards to the evidence of damage to the property, in saying that the potential is not evidence of damage, I would again refer back to the police comment. I mean, if what he's saying is, it sure seemed to me that as he went and looked at the property, a 4-foot tall fence is not sufficient because he's recommending other things that need to be done. So as we talk about the historic nature of this property, as we're talking about the view corridor, we're talking about how it looks in relation to other properties. I mean, we address the historic nature. The character of the fence itself has been approved. So we're only talking about the height. And so all we are thinking about is, as we consider in our mind what that would look like, the fence as it is now, or 2 feet shorter with bushes and no trespassing signs, is much more out of character for this property than the fence as it exists. Certainly considering the property right across the street that has an entire block of a fence that is identical to this one, but taller. And just one more thought. I did mention this, that there is, as we just walk down that street, to not see another fence with bushes and signs, and to hear this policeman say there does need to be additional work. This fence is appropriate, and it is certainly within the character, and it does satisfy all these conditions. So for those reasons, we ask that the city's decision be overturned.
Okay, thank you. Appreciate everybody's input. I appreciate everybody's professionalism. I will take this matter under advisement and issue a decision within about the next 10 days. It'll be a written decision, and we'll get it out to all the parties. Any other questions, concerns, or issues that you'd like to bring up at this point? Anybody? No?
Thank
Okay.
you.
Thanks, Eric.
Thank you again. And yeah,
Actually, can I just ask, just to confirm, you do have all of our exhibits?
so I have everything that's in the staff report. If you look online, That's where I got it from, is from the online, posting of it. Let's see here. You go through, and I'll let you know what exhibits I do have.
I'm looking at it as well. Okay, it looks like they are there.
They all in there? Okay.
So they're all numbered after the appeal letter in the bottom right corner. And we submitted a total of through Exhibit G, and yeah, they're all in that staff report.
Okay, perfect. Always good to double check. Thanks.
Yeah, thank you.
Okay. Well, everybody have a good night, and again, thanks for your participation.
Thank you.
Thank you
Thank
very
you.
much.